First case is Tolliver v. State of Florida. Appellant ready to proceed?
Yes, Your Honor. May it please the Court, I'd like to reserve 5 minutes for rebuttal. Your Honors, I'm Barbara Becheris, and I'm here representing Jimmy Tolliver, who asked this Court to reverse his conviction for second-degree murder. The primary reason for granting Mr. Tolliver this relief is that his trial was tainted by the improper admission of reference to a prior arrest record when the officer who arrested Mr. Tolliver was allowed to testify that he had obtained information about Mr. Tolliver by using Mr. Tolliver's name in a database that lets him pull up prior arrest records, photos identifying information of the potential defendant, and I believe the particulars of the defendant's last known arrest. This information came in response to questions when he was describing how he stopped Mr. Tolliver on the night of the shooting for which Mr. Tolliver was later convicted. The shooting had taken place at approximately 1:30 in the morning. A little bit before 1:30 in the morning. I believe the stop was approximately then. The officer already had the name of the suspect, Jimmy Tolliver, because there were eyewitnesses to the shooting. And in a pretrial agreement, the state had already agreed that references would not be made to Mr. Tolliver's prior record, to his driving history, to any prior arrests, and that, in fact, the only thing that the officer would testify to was that he had run the license tag on the car that Mr. Tolliver was driving before he stopped him. However, at trial, as I said, he proceeded to testify that he had used Jimmy Tolliver's name to check a database of arrest records. The defense immediately objected, and then moved for a mistrial, and that motion was denied. Instead, the judge decided to give a curative instruction, which was, ladies and gentlemen, I want to instruct you that you should not draw any inference from this officer's testimony that Mr. Jimmy Tolliver has an arrest record. Your Honors, it's the appellant's position that the mention of his prior arrest record was presumptively harmful, and that this curative instruction was completely insufficient to cure any damage caused by reference to his prior arrest record. It was insufficient, first because it was ambiguous. The instruction can be understood to mean, yes, this defendant has an arrest record, but don't draw any additional inferences from that. Or it could be understood to mean, don't infer from what you just heard that this defendant has an arrest record. However, the appellant would argue that when an officer testifies that I had the name of the suspect, I used that name to pull up information in a database that contains information on prior arrests, that the only inference a jury could draw from that and would draw is that indeed this defendant had a prior arrest record.
Well, I'm looking at the transcript portion, which you thoughtfully put in your brief, and we do appreciate that. But couldn't it be easily argued that the jury might draw the opposite inference because the officer didn't know whether your client had an arrest record, and he never told the jury whether your client had an arrest record?
Your Honor, the objection was made, I think, quickly enough to keep him from specifying specifying the information he drew up in that arrest database. But when the original question is, did you have any other identifying, or did you have any other information about this defendant? And he said, yes, I had the name of a suspect, Jimmy Tolliver, and using that name.
Well, you almost have to argue, though, that if you separate out this statement, and you were just making the germane statement, using information that using that information, I pulled a computer program we have in our cars which pulls up all arrest history. And that's it. And he had also told the jury I had the name of a suspect, Jimmy Tolliver, who I believe is your client.
Correct.
You'd almost have to conclusively presume the second part of that statement is more damaging than the first part of the statement, which is he's after Jimmy Tolliver because he thinks he did it.
That's true, Your Honor. There were eyewitnesses to the shooting. There was no dispute that Mr. Tolliver.
That's my question, is how could that not be at least as prejudicial as the fact, oh, as long as I'm looking for this guy, I'm going to run it through the NCIC or whatever they have.
Because, Your Honor, Mr. Tolliver is on trial for the shooting of that night, and he deserves to be tried for what happened that night, not for any inferences or presumptions the jury may create by learning that he also had an arrest record on top of that. That's the whole reason that courts have held that this type
That's
of
why
error
I phrased the question the way I did, Ms. Bicharz, because if he had said, Jimmy Tolliver, that rang a bell. I've seen this man on the streets before. I immediately went and pulled an arrest record. But that's not what he said, is it?
No, Your Honor, but he did say that he used it in a database of arrest records. And the inference that would be drawn from that is that there was an arrest record for Mr. Tolliver. It was, I believe, compounded by the curative instruction that followed, which said not only, I think the evidence is going to, not only that this officer's testimony that Mr. Jimmy Tolliver has an arrest record, but also the court added, I think the evidence is going to demonstrate that he was not the owner of the automobile, which had been encountered at this point. And in fact, the search of the automobile tag, the license tag, is what had already been agreed to. That was what the state had stipulated that it would introduce, and that was a completely separate search based on the license plate of the car Mr. Tolliver was driving that revealed that he was driving a car registered to Gerald Tolliver and not a car registered to him. But so the instruction and the evidence that followed that actually reinforced that the initial search was a search of arrest records pertaining to Mr. Jimmy Tolliver. This, excuse me, Your Honors, the type of information I think elicited here is similar to the information that was elicited in Wolcott, a 5th District Court of Appeal case that I cited in the brief, where a corrections officer was allowed to testify that she located certain identifying information about a defendant from records that she had. She didn't come out and say, yes, he was incarcerated in my facility before, but she was allowed to say that she used records to locate information about him, and the court said that found that the inference that would be drawn from that was that indeed the defendant there had a history of incarceration. Furthermore, the Wolcott illustrates that this type of error, even when a curative instruction is given, is not harmless where the evidence against the defendant is not ironclad. Here, the evidence that we're talking about when we say the evidence is not ironclad is the evidence of malice, the evidence that was necessary to convict Mr. Tolliver of second-degree murder rather than some lesser charge. There was no dispute going into the trial that he was present at the scene, that he held the gun, that the gun fired, that the discharge of the gun killed Mr. Sessions. None of that was in dispute. The entire dispute and the entire issue for trial was what was his state of mind at the time that happened. And so that's an additional reason, Your Honors, why introducing evidence of prior arrests was especially harmful in this case. Even if you don't regard it as presumptively harmful, it was harmful because Mr. Tolliver's state of mind was such a crucial issue. And another illustration of that point is the case of Brooks v. State, which was a 2nd District Court of Appeal case where a curative instruction was given after a reference to a previous incident of domestic violence in a trial for aggravated battery based on domestic violence. In that case, the improper reference didn't even come from a law enforcement officer. It came from the victim, and the victim testified that the defendant had been sent back to prison, from which the court found that the jury could infer that he had been convicted of something similar before. The court gave a curative instruction in that case, telling the jury that the answer was non-responsive, that it would be stricken from the record, and that the jury should ignore it. But the 2nd District found that this curative instruction was likely to be ineffective for 3 reasons, and 2 of them are directly applicable here. The first reason was that the statement was an assertion of fact from a witness who would have personal knowledge of those facts. It was not some indirect reference. It wasn't some hearsay statement. It was a statement of the witness recounting her own personal experience. The second reason in Brooks that the curative instruction was ineffective and the error was harmful was that evidence of the defendant's past behavior cast doubt on his theory of the case for which he was being tried, which was self-defense. And those two reasons are directly applicable to Mr. Tolliver's case. The testimony of Officer Hudson, who's the officer who talked about the arrest records, was based on his actions in apprehending Mr. Tolliver. And so he was testifying to something of which he had personal knowledge and to actions that he personally took. And it's highly unlikely that a curative instruction would cause the jury to disregard that as somehow beyond the scope of his knowledge or improper for him to have referred to. And also, Mr. Tolliver...
In applying the abuse of discretion test, would it be appropriate for us to look at the entire context of the trial and issues, particularly whether the assistant state attorney made further mention of this or whether it ever came up again or anything such as that?
It is proper, Your Honor, to consider the context, and there were not additional mentions or emphasis placed on the arrest record after the discussion, the objection, the motion for mistrial, which was denied, and then the curative instruction. So we're not maintaining that the state tried to capitalize on that error beyond the original error in an improper way. But the introduction of that testimony was harmful to Mr. Tolliver because of the weight that the jury was likely to give factual statements from a law enforcement officer who was describing the initial stop of Mr. Tolliver. And also, and this relates to, again, to the second reason in Brooks, because of his theory of self-defense. Mr. Tolliver's theory of the case was that he was acting in fear for his life or Ms. Jacobs' life. He was responding to a situation where the victim in this case, Mr. Sessions, had earlier that day menaced Ms. Jacobs with a knife, had held her to the ground, had threatened her. She had called Mr. Tolliver to come get her from that situation, and he expected trouble when he went back. And the record reveals that he tried numerous times to talk her into not going back to avoid contact with Mr. Sessions. And yet she insisted. He took her back, and so he brought the gun with him for protection. So that is the second reason from Brooks that's analogous to Mr. Tolliver's situation, showing why the admission of that testimony tainted the trial and was harmful to Mr. Tolliver. Your Honors, I see I'm in my summing up time, so I'd like to reserve the rest of my time for rebuttal. Thank you.
May it please the Court, I'm Judy Bone for the State. The State's position is that the Court cured the error by the reference to the arrest record by implying that the arrest record belonged to the driver of the car. And the way the Court did this was the witness stated that he had not only the name of Jimmy Tolliver, but he had a description of a gold car. And the witness had said, I have spotted the gold car. And after that information, that's when the witness says, and with that information, I was able to find an arrest record. So after this testimony, the Court cured that by going back on the record and stating that to the jury, I don't want you to draw any reference that Mr. Tolliver has an arrest record. And he also said, in fact, I think the evidence was going to demonstrate that Mr. Tolliver is not the owner of the car. Then the State immediately elicited testimony from the officer saying that the actual car owner was not Jimmy Tolliver, it was Gerald Tolliver. So the implication for the jury was that this was not Jimmy Tolliver's arrest record. And the second reason why we think it's harmless is because based upon Jimmy Tolliver's own story of events that he told the police, based upon that, that proves second-degree murder and disproves any valid defense of others or defense of self. What Mr. Tolliver told the police was that when he pulled into the apartment complex with Sandra, he saw Mr. Sessions running over to the side of the car. And he didn't see a weapon, and Mr. Sessions opens the car door. Mr. Sessions doesn't say anything about Mr. Sessions trying to get it in the car or trying to pull Sandra out. He's seen no weapon. But at that point, he gets out of the car, he pulls out the shotgun, and he tells Mr. Sessions, why are you messing with her, man? He pulls up the shotgun. He admits to seeing her ducking, to seeing Mr. Sessions ducking. He fires at him and kills him. Based upon that, that's enough to show malice. It's not a case where we have he said, she said. Based upon what he's told the police, that's enough to find second-degree murder. And that's why the information about the arrest, position is it was cured by the state, by the court's curative instruction. It was cured. But in any case, it was harmless because based upon Jimmy Tolliver's own information, on his own story to the police, it proves second-degree murder. There's also a complaint about the instruction may not have been clear enough. Well, our position is it really was clear. But if it was not, that was the defense's obligation at the trial to make it clear. Once it's clear that the court isn't going to grant a mistrial, defense should have said, I want the curative instruction to say this, or I want the curative instruction to say that. Defense didn't do that. So now is not the time to complain about it. It was then. The second issue has to do with a photo. In this case, the defense says the jury would stipulate. But the problem with the stipulation is the jury can reject it. There's only one chance for the state to prove its case. They don't do it first time. They can't do it the second time. It was relevant. There's been no Florida Supreme Court case where there was one crime scene photo entered where it was found inadmissible. Usually it's inadmissible where it's cumulative or where there's after-death damage to the body. That wasn't the case here. And the third issue is ill will. The defense claimed there wasn't sufficient evidence of ill will. The state says there was plenty of evidence of ill will. He pulled up, Mr. Tolliver pulled up, got out abruptly. He cussed at Sessions. He got out of the car. He pounded on top of the car. Mr. Sessions says, I just want to talk to her. I just want to talk to Sandra. At that point, he cusses at him again. He gets the shotgun out. Mr. Sessions is described running up and down the side of the car, ducking, and Mr. Tolliver shoots him in the head. So I think based upon that, there is plenty of ill will for the second-degree murder. You don't have anything further? That's all I had.
Thank you. Rebuttal.
Yes, Your Honor. Thank you. In response to the depiction of events, what you've just heard is what could have been found based on testimony, but it was not based on undisputed testimony. There was also testimony that Mr. Sessions was banging on the car, disputed testimony about whether he was trying to get into the car. And so the fact that the evidence can be viewed one way or another leads you to the harmless error test. Is the view of the evidence colored by evidence or information about Mr. Tolliver that was improperly admitted? And Mr. Tolliver's position is that it was. The record does show that Mr. Sessions was not carrying a weapon in his hands when he approached Mr. Tolliver's car, but Mr. Tolliver did know that he carried knives and that earlier in the day he had threatened Ms. Jacobs with a knife, and all he knew was that the victim was approaching the car with clenched hands. Those hands were later revealed to be holding cigarettes and a lighter, but it does not take away from the fact that Mr. Tolliver knew that this was somebody who carried weapons and who earlier had assaulted Ms. Jacobs. Regarding the photos, Your Honor, there were several crime scene photos introduced, and actually a number of them were not objectionable. A number of them showed the body of the victim covered and still showed it in relation to other objects in the crime scene. The photo to which we're objecting is the photo, the close-up photo of the body showing the head injury in gruesome detail, which was used twice. It was used during Ms. Jacobs' testimony and caused her to cry out on the record that, oh, God, I don't want to see that, because it's a very graphic depiction of a severe head wound which ejected the victim's brain from his head.
It seems, though, and I think the State may argue this, that it might be relevant and even important for the State to be able to demonstrate that the victim was perhaps taking a defensive posture, crouching, rather than an aggressive posture at the time that he got shot.
The problem, Your Honor, if it were probative of that, yes, it could be relevant to that point. But even the medical examiner couldn't testify that the wound was consistent more with ducking than with leaning. He stated,
Well, but even a layperson can look at that photograph, unfortunately, and tell that he wasn't shot face on.
No, he was not. But the layperson cannot infer from that that it's more or less probable that he was leaning to reach into the car or that he was ducking behind the car. And that's the whole problem with the relevance of that photo. The effect of that photo.
So you don't think there's any relevance to an inference that he was either shot in the back or side of his head? You don't think that's...
To the extent that it's necessary to show where he was shot, there were autopsy photos. There was an X-ray of his skull that was also admitted that showed the wound. Also very graphic photos, Your Honor, but not as graphic as the one objected to, which could have had the effect of convincing the jury this was a horrible injury. It could only have been inflicted by somebody who really wanted to hurt this man. And that's the harm from admitting that photo. Thank you, Your Honors.
Okay.